It is said that the stability and growth of any nation depends on how strong and responsive the judiciary of that nation is. The custodians of law have a very crucial role to play. And one important role is to generate awareness amongst people so as to make them responsible and enlightened citizens. Today, we are privileged to have the law guardians and who's who of the judiciary amongst us who would be shedding light on a very pertinent topic. On behalf of lovely Professor University, I, Sarabjit Singh Kuatra, heartily welcome the galaxy of legal experts, intellectuals, and eloquent minds. What is contempt of court? What is the scope of contempt of court? And what are the consequences of contempt? Today's panel discussion will answer these and many more questions that come to our mind. A special and hearty welcome to Honorable Justice Kurian Joseph, Supreme Court of India. We welcome and recognize your presence, sir. We would also like to welcome on board Mr. Rupender Singh Suri, Additional Solicitor General, Government of India. Privileged to welcome now one of our own, Dr. K.P. Pillay, Senior Advocate of Supreme Court of India and Director NTPC. Of course, all the efforts and the spirit behind this initiative, our own Professor Dr. Dharam Buddhi, Executive Dean, Innovation and Research, lovely Professor University. We welcome and recognize your presence, sir. And moderating today's event, I would be privileged to welcome on board Dr. L Mony, Professor and Dean, Hindustan Institute of Technology and Sciences, Chennai. But on the top of it, our special thanks to Dr. Sanjay Modi, Executive Dean, lovely Faculty of Business and Arts, for being present on this event of enlightening and being here to welcome our experts on panel. Again, recognizing the efforts of Dr. Meenu Chopra, Associate Professor, School of Law, and in absentia, Dr. Sunaina Ahuja, Professor and Associate Dean, Head, Human Resource Development Center. Dr. So you've always been a votary of such meaningful interactions, and we could not think of a better person to set the context of this very, very valuable and insightful interaction that's going to follow. So I would like you to please come on board for your opening remarks. The privilege to invite Dr. Sanjay Modi on board for his opening remarks, Executive Dean, lovely Faculty of Business and Arts.
Well, good afternoon, everyone, and thank you, Kuatra-ji. I thought you would give me the easy task of welcoming the guests and getting away from, saying something which, is an absolutely uncharted territory for a man like me. Yet you have put me in a difficult spot. So, but yet I would still start by extending my, very warm welcome to all the esteemed panelists, the Honorable Justice Joseph Kurian of the Supreme Court of India, Rupender Suri ji, Additional Solicitor General, Government of India, and Mr. Pillay, Mr. Professor V.L. Mony, and our own Professor Dharam Buddhi. A very hearty welcome to LPU, and thank you so much for sparing your time, and I'm sure your wisdom will rub off some of the faculty and students and do a fair amount of good to us. I am absolutely nobody to speak about this topic, and I don't consider myself competent. Yet I would venture to present a layman's appreciation of the topic. And at times layman's appreciation in today's world does count a bit. At times there is a flash in the pan and one might say something which appears meaningful, and some suo motu notice may be taken by the judiciary on such observations. Anyway, you see, it goes without saying that the rule of law is the most important foundation for any democratic, civilized society. I think it is by virtue of the legal system that there is some semblance of sanity in this world today. Otherwise, the kind of turmoil which the political governments, politicians, bureaucrats, and even the civil society is, is putting the entire world into, it would be in bits and pieces had it not been for, the, I would say, activism, literally, of the judiciary, which at times asserts also itself. So, actions of the governments at times are so arbitrary or contentious that the courts need to intervene and interpret their conformity to the Constitution and the rule of law. Laws like, for instance, the Right to Information Act and the Lokpal Bill, though not fully effective, yet keep a leash on the indiscretions of the individuals and the governments. So that's a saving grace. But there are a few developments which are taking place in the society, which though are good to the society as such, but yet are introducing so much of complexity into the system. For instance, digitization, human rights, concern for human rights, increasing focus on freedom of speech and right to privacy, intellectual property rights, international law. Though very extremely meaningful kind of developments, yet they are adding to the complexity of the rights of the individuals, the corporations, and the sovereign states. Everybody's rights are getting mixed up and confused, and people are asserting that whose rights should get precedence. And hence, these require the intervention of the Honorable Judiciary. And it is absolutely amazing to see how industriously and how dispassionately the judiciary is able to maintain its neutrality to establish the rule of law. And before I speak of what you started with, the contempt of court, I would seek pardon of the Honorable Justice and the panel members while referring to this very sensitive issue, because you never know when you put a wrong step and you are charged with contempt of law, contempt of court. We all understand it's extremely meaningful, and it is absolutely essential to ensure fair administration of justice. The law and the people delivering law don't need to be challenged all the time. But at times one gets a sense, this is my observation, at times one gets a sense that, the contempt cases are on the rise. I don't have data to support it, but one generally gets a feeling that contempt cases are rising, and there's a fear of further escalation in the trend due to assertion by the civil society and the so-called intelligentsia. I mean, everybody poses to be intelligentsia, and the civil society bothers about no rules and regulations, be it a developed country like America or developing countries. There's, rioting and arson and all kind of protests. At times genuine, at times not too very genuine in the eyes of the court. That's observation one. Secondly, at times it's very painful to note, and this my observation is particularly addressed to Honorable Justice Joseph Kurian Ji. It is very painful to note that the judicial officers, particularly after retirement, are put to very uncomfortable scrutiny by the media and the civil society. And I don't know to what extent does it impact their functioning while they are in position. But to a common man like me, it does give a feeling that it might, impinge on some corner of the mind. Though when you listen to judges, I've heard a lot of people to speak about what they have done during when they were on the bench, and they justify every action of theirs. But then, being humans, it does at times raise certain questions as to whether it influences their, ability to take the right kind of decisions. And may I request the worthy panel members to kindly elucidate as to how easy or difficult will it be to uphold the rule of law in such hostile kind of environment. With these few words, I once again extend a very warm welcome. I hope I have not myself made any indiscretions which would offend the judiciary and the illustrious panel. But that's what a layman's interpretation is, and I hope you will excuse me for any indiscretions that I might have committed. And with these, I once again extend extremely warm welcome, and I think this interaction is going to clarify a lot of doubts and prove very meaningful to the students and faculty who are joining us for this panel discussion. Thank you so very much for this opportunity.
Thank you, Dr. Modi, for a wonderful and a much needed stimulant to this food for thought that's about to follow. So thank you for that context setting. And now I would like to formally welcome and introduce on board our eminent panelists. To begin with, it's a privilege to have Honorable Justice Kurian Joseph, Supreme Court of India. Your Honor believes that people have high expectations of the judiciary and that it should play a proactive role to meet their aspirations. Known for his humane and compassionate approach to law, a strong supporter of mediation even on bench, Justice Joseph was known for urging parties embroiled in litigation pertaining to personal relationships to settle their disputes amicably. Even since his superannuation, he is routinely appointed by the Supreme Court of India and various high courts to act as a mediator and arbitrator. Justice Joseph is also on the panel of mediators at Singapore International Mediation Center. So with such a proven track record and that humane touch that judiciary has to rub on to the ordinary citizen of India, I think he's the most appropriate person. So ladies and gentlemen, please join hands to welcome on board our first panelist of the day, Honorable Justice Kurian Joseph.
Thank you, Dr.Kuatra.
If you allow me the privilege, let me also introduce the second panelist of the day, the name who I think brought my memories back. Mr. Rupender Singh Suri, Additional Solicitor General, Government of India. He was also the President of Supreme Court Bar Association. He's also held the position of Secretary General in Seoul and is an active member of the International Bar Association. And why I said memories went back, he has been extensively involved with an organization that I am also an ardent student of, Junior Chamber International. He has been on the member of National Executive Committee, JCI India, and for 7 years he has conducted national leadership camp seminars across India, Nepal, and Sri Lanka. So welcome on board a wonderful human being and an orator, Mr. Rupender Singh Suri. Introducing the third panelist of the day. Now I think he has become a part of the LPU family. I'm talking about Dr. K.P. Pillay, Senior Advocate of Supreme Court of India and Director of Maharatan NTPC. We had the opportunity of having Sir for another panel discussion about a month back, and his unassuming, full of humility, composure really captured the hearts of we at LPU. But his humility is backed by an intense legal intellect, and having over 20 years of academic accomplishment in law research. He started this practice and then shifted in the local bar and shifted practice to High Court of Kerala in 1990 and in the Honorable Supreme Court from 2005 onwards. He has a rich academic base also and was the resource person at the National Judicial Academy, Bhopal. So welcoming one of our own, Dr. K.P. Pillay, the third panelist of the day. Now a privilege to again welcome one of our own, Professor Dharam Buddhi, Executive Dean, Innovation and Research, lovely Professor, University. Dr. Buddhi has more than 40 years of cumulative excellence in academics, research, and administration. He is a respected researcher of international repute and has come up with wonderful patents and papers to his credit. So welcoming our own Dr. Dharam Buddhi, the fourth panelist of the day. And the person who matters the most, the moderator of the day. Privileged to welcome Dr. L Mony, Professor and Dean, Hindustan Institute of Technology and Science, popularly known as HITS, Chennai. He's got 20 plus years of academic research and professional record. He was also the principal of Kerala Law Academy Law College some time back. And today we have the privilege of having Dr. L Mony as the moderator of this, to follow wonderful interaction on a very pertinent topic. So welcoming all these team dignitaries once again on board and requesting Dr. L Mony for further proceedings. Sir, the floor is all yours.
Minister, unmute your mic. Minister, please unmute your.
Good evening, all respected guests, respected Sarvajit Singh, Gatra, Dr. Sanjay Modi, Dr. Dharam Buddhi, then our guests of the day, Justice Kurian Joseph ji, most respected Rupender Suri ji, Dr. Pillay, and all other esteemed participants, including Meenu Chopra, the HOD of the Law Department. I'm very glad to have this session being organized here. Actually, this topic is very significant, and it talks of contempt of court versus rule of law. We know that India is a democracy, and in every democracy there is a functioning of legislature, executive, and judicial. As far as India is concerned, India is a perfect democracy. And in India, the balancing act done is very excellent. And it has seldom failed. It has never failed. Because in many nations, whether in Pakistan or some other country, there has been superseding of one wing over the other. But in India, the judiciary has shown its most respect and dignity with which it has functioned. And the contempt of court is a tool in the hands of the judiciary to have its steps implemented. And however, the Supreme Court and the High Court, who are having the powers of exercising the contempt of court, has been doing it very judicially and very perfectly, that there has been no case of excesses and has been balanced to a great extent. However, there can be criticism for judiciary judgments and regarding the functioning of the democracy in any democracy. So this is the basic topic. I should say the contempt of court versus rule of law. As the inaugurator and the first speaker, we are having our most respected Shri Kurian Joseph ji, who is the retired Judge of Supreme Court of India. And I am very glad to say that he was an alumni of the Kerala Law Academy, where I have been the principal for nearly 2 years. And now I am in HITS. I'm very glad that I am also a previous alumni. I am also from the Law Academy. And he has gone to a great height, that he has been distinguished himself for very many things, which includes his major decisions regarding the National Judicial Appointments Commission, triple talaq, etc. His judgments were very, very powerful, and he has been discussed all over India. And he has been also known for delivering very perfect judgments for more than 1,000 judgments in his career. And he has demonstrated support for the justice, by disposing nearly 8,600 pending cases in Supreme Court of India. So he is a very great luminary who can very well discuss the topic of contempt of court. And I request most respected Kurian Joseph ji to take over this inauguration and express his view.
Thank you. Thank you, Professor Mani Venkatalaxman, for your kind words of introduction. Thank you to Shri Sarabjit Singh Kothra, Dr. Sanjay Modi, Dharam Buddhi, Professor. They are the gurus. So I thought I will address the gurus first. And my beloved friends, Rupender Singh Suri and Dr.K.P.Kylasanatha Pillay, and dear other members of the faculty of the university, and my dear students, and other dear friends who are part of this program. Let me first of all congratulate the organizers for having thought of a subject, discussion on a subject which is, as the previous speaker said, it's very current, very relevant, and very hot. And on the observation of Dr. Sanjay Modi about the predicament of judges after demitting their office being subjected to public scrutiny, let me make it very clear. Those judges who have acted well from the office have never been tried by media or from the public. Those who are subjected to public scrutiny and tried by media are people who either failed or did not rise up to the expectations or have otherwise been not able to discharge their duties to the best of ability, knowledge, and belief. You know, the oath a judge takes when he enters office, that he will bear true faith and allegiance to the Constitution of India, not to anything else. So a conscience of a judge is the constitutional conscience, no other conscience. I may have my own other moral conscience differently shaped by my religion, by my ideologies, my philosophies. No. The moment you are a judge, your conscience is only the conscience of the constitutional conscience, nothing else. If I can quote Shakespeare, nothing else, nothing more. This is the standard of rectitude the judge should have. And he is appointed only to uphold the constitution and the laws. After having borne true faith and allegiance to the Constitution of India, and that he will uphold the constitution and the laws. Not even the President of India takes oath for upholding the Constitution. He will take his oath, is told in the schedule, Constitutional schedule is to defend the Constitution, protect and defend the Constitution. Only the judge has a duty of upholding the Constitution. And that is why people have this very high expectation. And that is why people take this painful task of making a judgment of a judge. There's the only occasion people make a judgment of a judge, that is after his retirement. Having said that, let me come to the topic, because I thought before I forget that, since you made a very poignant observation or a remark on that aspect, I thought I will touch that. Well, what is rule of law? Let me ask that question. What is rule of law? Is rule of law, rule by law. For everything there is a law, and law governs everything. Means there is no arbitrariness. There is no rule in the country as somebody wants. Be it the Chief Justice of India, be it the Prime Minister of India, be it the President of India, be it the judge, be it the lawyer, be it the professor, be it the principal, yes, anybody. Be it the retired foreman like me, yes, everybody is governed by law. Law is supreme. So, for the smooth functioning of a country in a democratic country, there needs to be a legal framework for all our conduct. And that is as simple as what is called rule of law. We don't have to go to so many judgments to explain what is rule of law. This is very simple. You are governed by a rule for everything that you do in society. That is the democracy. And in Indian democracy, we have a preamble which says, which has in fact secured to us, we made for ourselves, and it has secured to me, secured to me justice, equality, liberty, fraternity. What sort of fraternity? Fraternity assuring my dignity. It's not simple fraternity. Yes, so secured things are justice, equality, liberty, and fraternity. And what is assured to me is a fraternity with the dignity of my as an individual. And what is my dignity without liberty? What is my dignity without freedom of speech and expression? Therefore, our constitution is a constitution which hails expression and regulates expression and negates suppression. So we live in a democracy where we have a voice, and regulation is only noise, and prohibition is silence. That's not the silence. This is as simple as it is from the constitutional perspective as to what the rule of law is. And therefore, this article, just to move from the preamble, we have articles 14, 21, and 14, 19, and 21. All these 14, 19, and 21 read together will speak about my right to lead a dignified life where I have a voice in my country and I have a space in my country. This is the quintessence of the rule of law as far as a common man. You rightly use the word common man, as a common man is concerned. The moment this voice and space is denied to the common man, we say we don't live in a democratic country. And this that is right to live a dignified life. And this article 21. It's not simple. It's right to live a dignified life. And this freedom of speech and expression is part of that right to lead a dignified life. And Article 19 says, all citizens shall have the right to freedom of speech and expression. And that is regulated by certain certain restrictive clauses. Those restrictive clauses, in fact, one of the restrictive clauses is contempt of court. Your freedom of speech and expression shall not travel to that extent of committing contempt of court. I can just read Article 92. Clause 1. Speech and expression shall affect the operation of an existing law. We are not concerned. Reasonable restrictions on the exercise of right conferred by the subclause of speech and expression in the interest of sovereignty and integrity of India, security of the state, friendly relation to the border states, public order, decency or morality, or relation to contempt of court, defamation, incitement of offense. These are all the guiding factors as far as the regulation is concerned. Since this regulatory process, you have a right in this democracy for freedom of speech and expression. We are concerned of the 9 factors, only one factor. That one factor is what is contempt. Now, if you look at the Contempt of Courts Act, this is one of the
Can I interrupt? Could you please adjust your audio a little? I mean, it is okay, but not very clear. So if you can try and see if you can come a little closer to the mic, that will give some clarity, better clarity. Sorry.
Come closer to the mic. Yeah. So one of the, I said there are 9. Yes. I hope whatever I spoke so far has been very clear. Yeah, I have some interference, which not some noise, which I have cut off. That was from the AC. Yeah, I think that's Professor Mani. Could you also please mute, because some background noise is coming from your phone also.
Okay.
That's fine. Yeah, that's fine. So if all others mute, there will be any disturbance in it. Yeah, that's fine. So what I spoke was, we have a constitution. We have a constitution which is democratic, which assures my dignity, which assures my freedom of speech, which is part of the dignity, and that is under Article 19, and that is regulated only by 9 factors. And in the Indian democracy, speech of freedom of speech is the rule of law, and the regulation is only by way of putting restrictions on 9 aspects, and silence is impermissible in the Indian Constitution. This is what I spoke, except the introductory remark on comment on observations on Professor Modi's predicament of retired judges. Yes. Now coming to this contempt of court. So what is contempt of court? So of the 9 factors on regulation, yes, 9 factors on regulation, I am dealing only with one topic, that is contempt of court. I said this Contempt of Courts Act is one of the very rare statutes which says the purpose of the act is to regulate and prescribe the limits of the jurisdiction of the court. That's something very interesting. I'll just read out to you. This is an act to define and limit the powers of certain courts in punishing contempt of courts and to regulate their procedure in relation thereto. As professors, as you come across any other statute where a law is made to define and limit the jurisdiction of the court, as far as this and regulate the procedure in contempt of court, there are only 2 courts who are permitted to punish for contempt of court by itself. Those are High Court, and the other is Supreme Court of India. Because these both are courts of record. Courts of record have the original power vested with them, reserved with them. They can regulate their own rules. They can punish for contempt on the basis of it. So, being a court of record, these are the only 2 courts. So, actually, and these are the only 2 courts which are given the power to punish for a contempt of court. Even the subordinate court, we call it subordinate in the sense in Article 235. This expression subordinate is used. Otherwise, every court is nobody is subordinate according to me, because everybody exercises the power of jurisdiction of administration of justice, not power, the jurisdiction. Only when judges think that they have a power, they go wrong. If they think they have only jurisdiction, they do right. So this is the whole difference. Well, right from the civil judge junior division up to the Chief Justice of India, this is the same thing. Everybody does the same role. As far as the judges, other than the High Court and Supreme Court are concerned, if there is a case of contempt, it just be referred to the High Court, and it is the High Court which takes upon this contempt of courts for a trial. Well, and this Contempt of Courts Act is to define and limit the powers of High Court and Supreme Court in punishing contempt of courts and to regulate the procedure in relation thereto. In the process, contempt is defined in Section 2, which says there is civil contempt and criminal contempt. Professor Modi spoke about the increase in the number of contempt contempt cases is not in relation to criminal contempt. That is in relation to civil contempt. Because when there is a judgment, the government doesn't comply. Then the people take the jurisdiction of the Contempt of Courts Act for punishing those persons who has refused to comply or who has not complied the way the court wanted to comply, etc. That's called civil contempt. That is under Section 2A, 2B. And we are actually, all the people are concerned, interested only to discuss about criminal contempt. So let me not deal with this civil contempt. So let me come to the crucial issue of, though I had a slip of tongue, I'm saying it's a crucial question of criminal contempt. Criminal contempt has 3 angles. One, it should be visible, anything spoken, written, presented, etc. 1, scandalizes or tends to scandalize or lowers or tends to lower the authority of any court. 2, prejudices or interferes or tends to interfere with the due course of any judicial proceeding. 3, interferes interferes or tends to interfere with or obstructs or tends to obstruct. So it is, if it actually does, or if it has a tendency, then it becomes a criminal contempt. And under section 13, in the matter of punishment, the law is very clear. I've rarely seen such statutes putting it in so clearly. Nothing contained in any law for priming courts, that means contempt of courts. No court shall impose a sentence under this act for a contempt. So even if there is contempt of court also, but if the sentence can be imposed unless it is satisfied that the contempt is of such a nature, what nature? That it is substantial. It should interfere with, not simply, substantially. Substantially tends to interfere with. What? Due course of justice. What is due course of justice? That is majesty of law. Majesty of law is upheld by whom? By the guardians, by the courts. So if the courts are to exercise the jurisdiction in upholding the law, interpreting the law, and the securing justice to the people in the constitutional way, people should have faith and respect for court. Unless it is respected, the people will not comply. Unless there is majesty of law is protected, people will not have any respect for law. This is the whole reason why due course of justice is actually an expression used. What they call the justice administration, due course of administration of justice is due course of justice, the way the courts are imparting it. And that is section 13. And we have 14, where we need to have something very, very what they call regarded use, because this is a very unguided and unbridled power. 14, because a contempt committed on the face of the High Court or Supreme Court. What is that? What is that on the face of it? Well, I can tell you a simple example. A lawyer or a person shouting slogans and not permitting the court proceedings to go on, or creating to see create a ruckus, as we see in these days in our parliament or assemblies, creating such a sort of ruckus in court, or some sort of when there is an interference in which actually obstructs the proceedings to go on, and actually which actually and the presiding officer, judge is not in a position to freely and fairly continue with the court. That is what is called the interference with the due course of justice on the face of it. That is section 14. And 15 is actually cognizance of a contempt of courts. It is either through the on the petition of the Advocate General or some other person with the permission of the court. This is actually contemplatively under 15. So is not actually provided as a route, but said and done, the Supreme Court says, the section 14 says, take action on its own motion or on a motion made by. So take a motion on its own is an exception to the normal route of the Advocate General, or the permission with the Advocate General, and with the with the person concerned, like solicitor, the particular the government officer, as far as other territories are concerned. So exceptionally it is provided that court may take action on its own also. And to me, I am inclined to interpret this provision on its own is in relation to section 14, when nobody need to move. When somebody in court interferes with the proceedings in court, obstructs the conduct of the court on the face of it. There have been certain observations in many judgments in this line also. I am not going to take you to any judgment, because my idea is only in the limited time. I mean, I have 5 more minutes, only to say what the issue is. Why this is a contempt? Why the Contempt of Courts Act has contemplated a route of a scrutiny at the level of Advocate General or Attorney General for the High Court and Attorney General for the Supreme Court. Reason is they are also constitutional functionaries. They are also appointed under the Constitution. Though they do not take oath under the Constitution, scheduled oath is only for judges, but they are also constitutionally contemplated appointees under the Constitution. They have a right of preaudience. They have a right to address the Parliament or the legislature, as the case may be. They have a right to be present in the cabinet meetings also, and they are called the first among the fraternity of lawyers, the leader of the bar. In the state is Advocate General, Attorney General is in for the Supreme Court. And Attorney General is not for the Supreme Court, Attorney General is for the country of India, for India, Attorney General for India, Advocate General for the state. This is the expression used in the Constitution. So they are not a person simply appointed by the government at its sweet will and pleasure. And the moment, of course, it is a pressure appointment, no doubt about it. But in court, they are a constitutional function representing the country in Supreme Court, representing the state in the High Court, and they have a right of preaudience also. Right of preaudience, if they are present, they have to be given the first audience. That's what is called preaudience. Well, this is actually what is the Contempt of Courts Act is concerned. And Section 23 has given power to the Supreme Court and High Court to lay down their own rules also. Well, it is in that context, since which is of current importance is Supreme Court. In the Supreme Court of India also has made rules referring to Article 145, the general power of the Supreme Court to lay down rules, and also Section 23, where the Contempt of Courts Act has provided rule-making power to the courts with the permission, with the approval of the government. No rule, even the Supreme Court also cannot make a rule without make it a rule without the approval of the government, because that is how because law making is the province of the lawmakers whom we elect. Court is only the what we call the interpreter and the guardian of the Constitution. And guardian of the Constitution. What is Constitution? Constitution means we. So court has to be the guardian of the people. This is the great role. In CPC, the trial side lawyers will remember this concept, parents patriot concept also. There's a guardian, the professors also must know. Well, in the courts made by the Supreme Court in 1975, there is a provision for a suo motu contempt also. In case Rule 3 says, other than contempt referred to Rule 2, that is the general one, the court may take action suo motu or on a petition by Attorney General, Solicitor General, petition by any person with the permission. So this scrutiny, I just wanted to complete that portion. This scrutiny is given, because otherwise in a contempt case, the court is the witness, court is the prosecutor, court is the judge. Therefore, all these roles are assumed when the court on its own motion. That is why I said it's an exception. A first level scrutiny is contemplated in the Constitution and under the Act also at the level of another constitutional functionary who is also equally interested and obliged and obligated under the Constitution to protect the majesty of the court. Protect the majesty of the court. That is why it's given preaudience also. That is the Attorney General for the Supreme Court and Advocate General for the High Court. In that rule, Rule 10 permits notice to the Attorney General and Solicitor General. Reason for issuing notice is the moment and the court issues a notice in a contempt matter, that moment onwards, the Attorney General or Advocate General steps into the shoes of a prosecutor. There cannot be a prosecution, there can't be a trial without a prosecutor, because it is the prosecutor. If those who are teaching criminal law, will know that the trial is opened by the prosecution. So they lead what the prosecution case is. And the defense by the accused is to deconstruct it or demolish it and establish its own innocence. This is the way the trial is conducted. And the criminal contempt comes in the realm of a criminal trial. It's under the criminal jurisprudence. It's a trial. So somebody needs to show that this person is guilty, despite the notice so much issued by the court. There must be somebody to assist the court. That is where Rule 10 says in a notice is issued to the Attorney General. So it is the Attorney General who has to lead the prosecution and say there is a contempt. And then the contemner, or rather the respondent contemner, need only demolish that the proposition led by the Attorney General or the Advocate General as the case may be. This is a scheme that is contemplated for a fair trial of a criminal contempt. My dear friends, this is all what I wanted to say generally for contempt. If there is anything left, we will certainly have time for interaction. I'll deal with that because my limited time, this is all what I wanted to say. Thank you.
Thank you very much, sir. And it was a very excellent explanation on the matter, and has been very good, great discussion on the topic. Now, any persons having any questions can put a question on that. Okay, I think then we'll go to the next person, next panelist, Rupender Singh Suri, the very senior advocate, additional Solicitor General, a lawyer with having a firm with more than 40 lawyers, is an expert in corporate law, domestic and international cases, who has represented central and state governments and public sectors. He has made appearances in very many important landmark cases, which includes right to privacy, Aadhaar judgments, data protection law, insolvency, real estate, and whatnot. And he is a great mediator and a great asset for the Indian judiciary and the judicial system itself. And I bow and respect you, sir, as a great personality of the legal profession. And I invite you to have your views on this topic. Thank you. You are welcome, sir.
Dr. Modi, the moderator of the day, Honorable Justice Joseph Kurian, a person who has taught us how to grow tall in stature by the conduct, and he is very tall person. He is all heart and is full of compassion, and it's a great honor to have met him, to have interacted with him, and to learn from him. My brother, Dr. Pillay, Professor Dharam Buddhi, Dr. Sanjay Modi, Kuatra Sahab, Meenu ji, and lovely professional university who has given me an opportunity to today speak some words. I am thankful to Honorable Justice Joseph Kurian for laying out what is the rule of law and what is contempt of court act and what is meant by it and how to go about it. Let me put it this way, that I am extremely intrigued by the topic of the day. Normally, I would have thought it would be contempt of court and rule of law. But what is written is contempt of court versus rule of law, which means that there is some lack of compatibility. Can it mean that rule of judiciary is overwhelming the rule of legislature and executive? If that is the topic, then contempt of court versus rule of law would mean this, that the court, by contempt of court act, by the media of court of act, can remain the ruling authority. Now, rule of law is not what Alice in the Wonderland is exposed to by the Queen of Spades, that cut such person's head and cut such person's head, and that is the law. Rule of law means really that rule is above everybody else and everybody is under that. Now, rule of law is laid down not at one place in Constitution of India, but at various places. We exercise the sovereignty through rule of law, but through different institutions: legislature, executive, judiciary, election commission, CAG. All these institutions are part of exercising of sovereignty through the Constitution of India. Now, having said that, we are so blessed in India. I don't think today the original divine rights of monarchy survive anywhere in the world. And I have yet to come across a country which doesn't say that I am democratic and I don't follow rule of law. Every country, whether it's China, Russia, Czech, or a dictatorship or banana republic, says we have a constitution and we abide by rule of law. Now that is what they say, but that is not what they practice. I had the privilege of taking a delegation to China about 10-15 years back, and I found that the party decides that who's to be tried for corruption, and the court follows that, and who need not be judges, and after 6 months is given a death sentence. Now that is the law as far as the China is concerned. Similar situations prevail in Russia. I also traveled through Czech, and in Czech I was very much impressed that most of the judges were lady judges. So I have said that you are very emancipated, that majority of your judges are lady judges. They said, no, Mr. Suri, please, if you look at the history, when Russia occupied Czech, then the least valued work, everybody had to work, but the least valued work and the most unpopular work was becoming a judge. And it is that time that the ladies were made judges, and that's why we have more lady judges than anything else. So we have to look at it, that what does rule of law mean in the context. Now, technically, pardon my saying so, Justice Kurian would excuse me, that there are times when even judiciary has not followed constitution, but for very good reasons. And I am thankful to the judicial overreach, which gave us a principle like basic features of constitution cannot be tampered with at all. It is, it just cannot be amended. Now that judgment maybe is the main judgment which protects.
Sorry, sir. Can I, Professor Mony, if you can mute yourself, I think your mic is creating disturbance. There's an echo.
So what I am saying is that judicial overreach has taken place. It is not the letter of constitution which has been followed even totally by the judiciary of Supreme Court, but they have understood the spirit of the constitution and they have tried to protect it. And in this context, the concept of basic features of the constitution being unamendable is a very good step, and country has benefited by this. Now, otherwise, by having just a majority, any provision of constitution could have been amended, and the rule of law would have gone for a toss. So thank goodness that Supreme Court judiciary decided to overreach in letter but not in spirit. Similarly, I think, though it's a debatable, is that when in early 90s they took the charge of appointing judges by the judiciary itself, that perhaps they did a great favor. Although this requires a lot of navigational improvements in checkings over a period of time. But contempt of court, according to me, we don't have to follow the Western countries, where in some countries the contempt of court does not lie, and they do not even believe in it. We don't have to follow that. We have to look at our own country. Judges are very vulnerable. They are very strong, but they are very vulnerable. They cannot do anything to protect themselves. They cannot justify their own reasoning and things like that. And for that, they depend upon the bar. But this time I found that when the contempt cases were going on in Supreme Court, the bar also did not come forward. And maybe it's time that judiciary must also realize that how important and indispensable the bar is, and not to forget them in hours when you don't need the bar, and just to remember them when you need them. So this is something of a thing that overall it has to be seen, though in judgments the justice system runs on the two wheels of judiciary and the bar, but in practice that is not happening in that extent. According to me, the law of contempt should be there in the Indian context, because look at the media, the television media that we are having. It will massacre each and every judge if this was not there. And look at the social media which is there, which will analyze everything and not let the judge take proper decision. And therefore, the contempt of court is a very, very important thing. The judges have been very, very gracious, and most of the time they have not allowed contempt because they know that the contemner at times wants that a contempt notice should be issued. And therefore they have allowed it to be die its own death rather than encourage the situation which is there. But I must say that judges are not supposed to be influenced by media or the public opinion. But in the present case, and I am going to take a very unpopular stand, that in the contempt of Prashant Bhushan, the court, having taken a decision that yes, contempt has been created, really diluted its own standing by saying that we will impose ₹1 fine, otherwise you will go for 3 months jail. I think that has really brought the stature of the Supreme Court down. It just seemed that the Supreme Court was begging the contemner that please apologize, give us a way out, we want to apologize. Now, if this was not a media trial, how could the media start commenting on it? I think Supreme Court should have said that media, no, you cannot influence us like this. Few months earlier, there was a case of Matthew Nedumpara. He had said that how son who's a judge in the Supreme Court, how could his father practice in that court? A contempt petition had been filed. The court decided, yes, contempt has been filed. 3 months sentence was given to him, which was suspended, but 1 year ban of practice in the Supreme Court was imposed upon him. Now, he's a social activist. He's also raising various kind of issues. Maybe it's more of advertisement than anything else. But why should two decisions in the Supreme Court differ so much over a period of time? A person may be very good, a person may have done a great job, a person may have worked for the society, but if he once commits a crime, the crime has to be punished. And I think somewhere down the line, the Supreme Court could have done better. In this whole episode, it's nothing but the stature of Supreme Court which has come down. The judgment is excellent, all points taken, everything ticked, but sentencing has been compromised because of the persons involved. And therefore, rule of law has been affected. In Supreme Court, I find three kind of lawyers over a period of time, and I'm not speaking, please, as a law officer at all. I'm speaking as a member of the bar and as a former president of the Supreme Court Bar Association. One set of lawyers is which keeps in believing in pleasing the judges at any occasion, personal occasions and official parties and all that. Second set is which does its own job and nothing more than that. And third is which tyrannizes the court, which scares them, which threatens them, and either my way or highway. And therefore judges are also chosen. If they give relief in their favor, they are praised. If they are not given relief, they are criticized. And you look at this situation, that this time the statement was made that 4 judges have killed the democracy in India. And an earlier contempt issue, it was said that the 16 Chief Justices of India are corrupt. Now, where does it take us? If we kill the institution itself, which provides the so much of solace, strength and protection to the entire country, and is the conscious keeper of the Constitution of India, how can we justify it over a period of time? And 16 judges of Supreme Court being corrupt, issue has not been taken up as yet. It's going to be taken up. Why has it kept pending for last 10 years or 15 years? It should have been taken there and then. If 16 are corrupt, please hang the judges here. If they are not corrupt, hang the person who is making the false allegation. And then the apology comes in. Corruption doesn't mean money corruption. It means so many things. But what does a common man understand by that? I personally think that contempt of court should be there. The courts should implement the contempt provision diligently, after due scrutiny, after application of mind, not because they don't like anybody's face or argument or anything, or to stifle the free expression and the thoughts of the persons concerned, but not to exercise that authority and sanction which has been given to you is also not being fair to the Constitution. So therefore, according to me, the topic should not be contempt of court versus rule of law. It should be contempt of court and rule of law. Thank you so much.
No. Thank you very much, sir. Thank you for a very useful and informative discussion. I think I will take the questions, the last part of the discussion. Now I invite our most important and very senior advocate, Dr.K.P. Kylasanatha Pillay. He is a senior advocate of Supreme Court of India, and he was basically practicing from Kerala High Court. And he is also a director of National Thermal Power Corporation, New Delhi. And he is an holder of doctorate. He is an academician too. His doctorate is on the topic of inherent powers of Supreme Court. Has been the academic side has been a kind of nostalgia for him throughout his career. And more than that, he was the member of Bar Council of Kerala more than 2 times. And he was the vice chairman of the Bar Council. And in many cases, I have seen as the member of the chairman of the Enrollment Committee of the Bar Council. And he has been a visiting professor in many institutions like New Walls, NLU, Jodhpur, VIPS, and so many institutions in North and South. And his knowledge in interdisciplinary topics is so interesting that he delivers very excellent lectures on the topic of jurisprudence, constitutional law, and all that. And I have very much enjoyed many of his speeches. And with most respect and regard, I invite Dr. K.P. Kylasanatha Pillay to have his view. Thank you, sir. Please have your views.
Good evening to all. Am I audible, sir?
Yes.
Yes.
Most Honorable Justice Kurian Joseph, sir. My friend Mr. Rupender Singh Suri, sir, Additional Solicitor General. Dr. Sanjay Modi, sir, Executive Dean. Dr. Dharam Buddhi, sir. Dr. Meena Chopra ji. My friend Dr. L Mony. And the most eloquent presenter of the today's function, Patra sir, and all the participants of today's debate, discussion on a very vibrant topic. While taking the mic after the speeches of versatile and prolific speakers like my Lord Kurian Joseph, Justice Kurian Joseph and Rupender Singh Suri, it will be like the position of a tail-ender batsman in a long-scoring, high-scoring innings. Anyway, I will present my views. I will follow the path shown by Justice Kurian Joseph, sir. Before that, may I thank Dr. Moni for making so much of positive observations about me. for which I don't think that I am that much eligible for such high praise. And to participate in a function with most venerable, respectable, lovable, affectionate Justice Kurian Joseph, sir. That itself is a sort of rich experience. Benjamin Nathan Cardoso, American Supreme Court judge and a jurist, who wrote a masterpiece work on judicial process, called The Nature of the Judicial Process, makes a very pertinent observation about judges in one of the chapters. Everything depends on the personality of the judge. The judicial process depends on the personality of the judge, the character of the judge, quality of the judge, broad-mindedness of the judge, accommodative nature of the judge. Such qualities I had experienced with my Lord Justice Kurian Joseph, even when he was a judge of the High Court of Kerala for a long time, thereafter as a judge of the Supreme Court, and even before he became a judge, while practicing as a lawyer in the Supreme Court, I knew his lordship. So, judges like Justice Kurian Joseph had shown the way for lawyers like me, so that we will mean business while doing the business of a judicial process. In Hamlet, Shakespeare says, "Act well your part, there all honor lies." The lawyer has to act his part. The judge has to act his part. None should overreach the other. The permissible limits should not be crossed. When a lawyer crosses permissible limits, that adds to the chaos, pandemonium in the administration of justice. When a judge behaves in a manner not proper to a judge, that sends wrong signals to the society, wrong signals to the people. In between, we have to examine this broad topic for today's discussion, that is the contempt of court and versus rule of law. As the previous speakers said, let me make a couple of submissions on what is rule of law. As Justice Kurian Joseph said, rule of law means law has to rule, not human beings. Your faith, your trust is in the law. What is the paramount law? That is the constitution of the country. So the judges are taking oath, as we very pertinently observed, by the constitution. But it is rule of law. Even if it is a king, and I think even today it remains to be the most pithy statement on rule of law, an observation made by Chief Justice Edward Cook on the face of King James I of England. King James I summoned his Chief Justice Edward Cook, and asked him, why you did decide that case in that way, whereas I had given you message to decide this in this way. I am the King of England. That came the reply. Probably a classic, most courageous statement made by any judge on the face of the judge, on the king. Be thou ever high, the law is above you. Perhaps Chief Justice Cook lost his job. That is another thing. But the history will respect Chief Justice Cook, and history will not respect that much King James I. So this is law. Be thou ever high, the law is above you. You may be Prime Minister, you may be President, you may be Chief Justice, but you have to be ruled by law. That is the rule of law. They have come the significance of judiciary in India. When Constitution was enacted in 1950, and the institutions under the Constitution started functioning, there was a competition among the institutions, the executive, judiciary, and legislature. Just like the Three Musketeers of Alexander Dumas novel, among the Three Musketeers, judiciary, legislature, and executive, judiciary had the intelligence and practical wisdom. Judiciary knew how to strike and when. And the period of competition soon became a period of confrontation, the second stage. And with Keshavananda Bharati's case, this confrontation was taken to the hilt, And the court told in no uncertain terms the executive and the parliament that you have no business to touch the basic structure of the constitution. And that is the rule of law. And thereafter, the executive and legislature came to be within the sway of the judiciary in India. And then comes the third stage of the progress of preeminence of judiciary among the three institutions. That is the period of confiscation. Judiciary has confiscated power from the other organs, and judiciary has now become superior most among the three, first among the three. And having confiscated with the judges' cases, we will decide who should be the judges of the Supreme Court and High Court. We will have primacy on opinion regarding the appointment of judges. And then comes the fourth stage, the present stage. It is a stage of conciliation. If Supreme Court wishes so, things will do like that. And the Supreme Court is that powerful today. Therefore, the duty, the responsibility of the court is also so immense. Power corrupts, absolute power, absolutely we know. It is one thing to have the power of a giant and another thing to use it like a giant. So Supreme Court, more than ever time, now has the responsibility to see that it acts well its part, as Justice Kurian Joseph very correctly and pertinently observed. There may be, and herein comes, and now I introduce the concept of contempt of court. This is the institution. See, this institution has protected the interests of millions. And you see, our while delivering welcome speech, Dr. Modi touched on the human rights aspect. See, for human rights jurisprudence, to the world, to the democratic world or rule of law societies, Indian judiciary has been a guide, philosopher and friend. Even the judges of the Supreme Court of United Kingdom has openly accepted that Indian Supreme Court has done commendable work in protecting the human rights. And even a letter addressed to the judge, Chief Justice, could be converted into a writ petition, and a redressal can be made. And as judges, they are not only mere logical decisions taken, they are involved in social engineering process. You know, I can cite again example in the presence of Justice Kurian Joseph. Hundreds and hundreds of family disputes have been solved, resolved, conciliated, mediated, even when the matter comes fiercely fighting before the court by Justice Kurian Joseph leading benches. So this is the mission of the court, and it has got a vision also. That should not be tampered. That should not be tampered by anybody. If that is to be tampered by a person who is coming to the court every day and practicing as a lawyer, then it is something serious. Suppose if a professor, if a lawman, if a layman, if a poor man makes an observation and it amounts to contempt, the court can excuse him. But a lawyer, he is an officer of the court also. He cannot take chances. And he goes on telling most contumacious statements. Two tweets for which Mr. Prashant Bhushan was taken action against. One tweet is with respect to the Chief Justice who was mounting on a motorbike, a very costly motorbike. But that I don't mind, because that should not have been. It should have been, even the court should have taken it very lightly. Okay, anyway, you have made such a comment, we leave it. But the second comment, second tweet, the four Chief Justices were corrupt. Where do you have the evidence? You are tweeting it like anything. When you tweet, the public is receiving a very bad message, signal about the judiciary. And when the judiciary asks you, you are saying you file a 25-page affidavit asserting your tweet, that I meant what I said. That is bad. That is against the interest of the society. That is against the interest of the nation. That is against the interest of the constitution. That is against the interest of rule of law. It is here that we have to correlate between rule of law and the contempt of court. See, whoever you are, however high you are, I will tell you an example. In 1967, Kerala state was ruled by a communist coalition. The chief minister was E.M. Shankaran Namboodiripad, who was the veteran ideologue of Marxism and communism in India. And E.M. Shankaran Namboodiripad, in a press conference, made a declaration that our judges are all feudal-minded judges. If a man goes to the court with a finely dressed and another man opposes him with a poorly clad litigant, the court will side with the finely judged litigant only. Such absolute nonsense was observed by the Chief Justice, the Chief Minister. The court took cognizance, and there was a petition moved by a member of the Bar Council of Kerala, who was also a member of the Bar Council of India, against these observations of E.M. Shankaran Namboodiripad, and he was convicted while in office. See, Chief Minister while in office is convicted. That is the charm of rule of law concept. Be thou ever high, the law is above you. And the matter reached the Supreme Court of India. Justice Hidayatullah made a wonderful judgment, finally confirming the conviction, even though the amount of fine was reduced, making an observation that Mr. Shankaran Namboodiripad does not know the basics of Marxism, Leninism also. That again is a what do you call a disqualification he had to bear. See, this court has kept the Constitution alive despite amendments, more than 100 amendments by the executive. See, the legislature, if the legislature and the executive are now functioning normally, that is because of the Supreme Court of India. That we cannot destroy, we cannot destruct, we cannot spoil the good work done by generations of judges, including my Lord Justice Kurian Joseph, by the whims and fancies and loose talks of lawyer, however high he is, however preeminent he is. What is the significance of a particular lawyer? I would like to bring to your notice one more aspect. When Prashant Bhushan was convicted for contempt of court, there was a huge hue and cry by people, so-called intellectuals who started writing letters, signing 150 signatures, 200 signatures and all. These people are judging the Supreme Court of India. These people are acting against the Supreme Court of India. Why you did not make a single murmur or whisper when Justice Karnan, a judge of the High Court of Calcutta from Tamil Nadu, was sentenced and he had to undergo for 6 months? Nobody complained. And Mr. Nedambara's case was mentioned here by my friend Rupender Singh Suri. When Nedambara also took up a very valid issue, he was campaigning, he was canvassing, he was contesting against this collegium system. It is for an enlightened person to have his own view. If I agree with collegium system, you have the right to disagree with the collegium system. And he made a mention in the court that the matter should not be heard by a particular judge. You have the freedom to say that. And then you made a mention that your father is practicing here. See, you should be generous. But he was taken action against. Then he was debarred from entering the Supreme Court premises for one. See the extent to which, impermissible limit to which the Supreme Court has gone, I will agree with whoever makes this observation. So this is something which is a balance you have to strike. You have to strike a balance, as Justice Kurian Joseph pertinently brought our attention to Article 19 of the Constitution. Article 19, 1A to G gives you so many freedoms. But Article 19, 2 to 6 gives you or makes you accountable to law. I will, to illustrate, bring reference of an Australian jurist called Jethro Brown. Jethro Brown says that when you consider law and individual freedom, worth of man on one side and unity of society on the other side. This worth of man is Article 19, 1 to G, and the unity of society is Article 19, 2 to 6. So you have to maintain that. For maintaining that balance, judiciary should be left very clean. Judiciary should be kept intact. Judiciary should be respected. Every inch judiciary should be respected. These are my observations. I am very much happy that a lovely professional university has occasioned a platform for making discussion of such a wonderful topic. Very illustrious speakers have spoken on this resourceful subject. And once again, I thank the authorities of the university and the organizers of this function, this seminar, for giving me also an opportunity, a wonderful opportunity to take part in this. And I thank you. I congratulate you. I thank again and again. Jai Hind.
Hello. Thank you very much, sir. It is very interesting topic and discussion has been made by you. and thank you for your very interesting talk. Now I am to invite Dr. Dharam Buddhi. He's a person who hailed basically from Indore. As a professor to the core, a great gentleman, a person of knowledge, a person who has got a lot of credits to his inventions and research. And he is a great professor because I have had experiences to work with him. He's a very, great coordinator, great leader. I'm a great inventor, a great scientist, whatnot. I cannot explain much. He's a great academician I have seen in my life. And with due humility, I invite Dr. Dharam Buddhi to have his words.
Thank you, Dr. Moni, for introducing me with so nice words. Honorable Justice Kurian Joseph, who has given us a very wonderful direction how the Constitution, the country should be running. Honorable Additional Solicitor General of India, Shri Rupender Suri, my mentor, Dr.K.P. Pillay, Senior Advocate, Supreme Court of India, and Honorary Director, NTPC, because that is the area where we are more interested in the power. And I think I will draw the power from your side. My friend and my colleague, Dr. Modi, a great researcher as well as a great writer. I have written, I think, 2 foreword in his books, and he has written wonderful books on corporate and human rights. My senior colleague, Professor Sanjay Modi, Executive Dean, University, Dr.Kuatra.Dr.Chopra, my faculty colleague, and dear students. I feel today is a great day at lovely Professor University that we have the galaxies of legal system of the country. We have listened Justice Kurian, we have listened Suri ji, K.P. Pillay ji, and we are directly coming through the views of opinion of Dr. Modi. As a person, I don't have any knowledge about the legal terminologies, legal education, and the reason I was even in the morning, I was asking Dr. Chopra that what should I speak, and because I have no idea about the topic, the system of legal education, and whenever I can speak sometime, but whenever we have the persons like Justice Kurian, Suri ji, and K.P. Pillay ji. So I thought, okay, let us try to do it, but my opinion will be like the difference between sun and a lamp. I think all who have spoken is like sun, Suraj, and my thought will be like a lamp, ek diya. So please forgive me wherever my words may not be matching with the legal education, with the legal terminologies. Honorable Justice Kurian very rightly said the importance of the Constitution. We should ensure the dignity of everyone. That is the duty of the apex court of the country, as well as the parliament and the local state assemblies of any country, including our nation. One of the very important, what I felt, he said that guardian of the Constitution is the apex court, perhaps. As a political system, the thoughts may be different. As an individual, the thoughts may be different. But it's the Constitution, the rule of law, which basically combined us that we have to go only this direction. Basically, Constitution shows us a light, a guide, how we have to go, where we have to go. As Dr. Moni has mentioned that I have been in Indore for a long time, and I think Devi Ahilyabai Holkar is very well known for her justice. And it is said that she basically punished her son the only son when he committed something wrong which may not be acceptable by the society. I think the legal system, and of course those persons, those leaders who are leading the legal system, they are the judges of the country, and the support is the advocates. Basically, they must have the highest respect in the society. I remember in our childhood, perhaps in a 5th or 6th class, we read one story of Munshi Premchand. He is a very well-known author in the literature, Panch Parmeshwar. And I think the Panch was not a good friend of one of the, you can say, one of the person who was going to defend himself. So therefore, was a client of the court of the Panch Parmeshwar. But the Munshi Premchand has written that the judgment given by the Panch was in such a manner, the Panch Parmeshwar in such a manner that satisfied everyone. What I mean to say, we have to create a faith and trust in the legal process. I think my honorable senior friends must be knowing that when there was a Harshad Mehta case, and I think the highest offices of the country were involved. And one of the very common word was used at the time, कि justice होना ही नहीं चाहिए, justice होते हुए भी देखना चाहिए. So that's the transparency we should try to have in our legal system. But I feel the contempt of court, I think as I have read some literature, some papers given by Dr. Modi yesterday, in India it was introduced in 16th century. But I feel maybe the word may be contempt of court, there may be contempt of society, there may be contempt of family, there may be a contempt of a teacher, there may be contempt of a institution like Supreme Court or Apex Court. So I feel it is not a new term. If in the family we feel the contempt of family, when the father is there, mother is there, we know what kind of the limitations we have, what kind of the thing we have to do, what we have not to do. So contempt of court is not only limited to the court, I feel it is limited to the nation, it is limited to the family, it is limited to the school system. When I'm a teacher in the class, I should not allow indiscipline to a student in my class. And I feel the same thing is happening in the court. If the judges are there, honorable judges are there, and the advocates are there, and the other persons are there, we cannot, and none can allow them to have an indiscipline inside the house of the court. So I feel the contempt not to be done should be part of every day and every time of our activities. And I mentioned that if in any institution, if you are insubordination, it is again a contempt of the institution. So please, we all have to follow certain rules and regulations. And if we will not follow those rules and regulations, the society and the country will be in danger, what I feel. I know in my previous university, one of the committee was there, and they asked something about the rules and regulation in the university. My registrar mentioned, इस university में कानून का राज चलता है. And that single word said everything. The committee did not ask any further question, and they were well satisfied with the system and left with positive notes from the university. So unless we have a Kanun ka Raj, unless we have a rule of law, then only perhaps the society and the nation can exist, the institutions can exist, can grow, otherwise they will not be able to grow. I feel as a common man of the society, as my senior colleague Dr. Modi has said, we are all part of a society. I feel, which I have felt, that feedback system, though the legal system may not be agreeing with that, like in the academic institutions, we have a feedback of a teacher. And then the feedback is being shared with the teacher to improve his or her conduct, the quality of teaching, the quality of evaluation, and quality of personal conduct. I feel it may be there, but I'm not aware of that. Similarly, in the judiciary, for the honorable judges, maybe the honorable advocates, similar system may be executed so that, may be implemented so that by receiving the feedback from the society, the receiving the feedback from the peers, from the advocates, from the clients, perhaps can make the system more transparent, and the contempt of court cases like that maybe get reduced. But I feel there is a need of more and more transparency in legal education. I have seen that personal relationship, I think Honorable Justice has already mentioned that when you are a judge, none belongs to you. You have to only see like Arjun ki aankh, कि मेरा judgment ठीक से ठीक होना चाहिए. So what I feel, when you are a judge, your individual behavior, your personal relationship should be far away from you. Your boundaries only should be to provide the best judge, and perhaps in India we do have that practice. I also have one small suggestion to the House that, like with the support of Honorable Supreme Court, Apex Court, the University Grant Commission introduced environmental studies as a compulsory subject at UG programs. And I think Honorable Suri also mentioned that legal education, which perhaps is not known to everyone. What's my right? I'm not aware, even if I'm a professor, I have been a vice chancellor to a university, but I'm not aware even today what are my rights, what are my duties, how I can protect for misdeeds. There is a need to provide in school education as well as in higher education something about the legal education, component of legal education, so that even school children can understand what my legal rights are, what I should do, what I should not do. Because we only came to know the legal frame only when we do commit something wrong and we are trapped in the system, then only we know, oh, I could have not done this. So therefore, I feel, as a personal opinion, everyone must respect the judgment of the court, and it's the powerful body. Everyone should be very sensitive and responsible to the society to make the system more and more reliable. No one should be allowed to make observations on the individuals and on the honorable judges. However, our honorable judges and the legal system should also make examples by their own acts. With these words, I will close my talk, and I thanks everyone listening me very carefully. Thank you very much.
Thank you very much, sir, for your practical suggestions, and we will be taking forward all your suggestions ahead in the future as a part of legal education, giving practical training and all other aspects for the students as well as the academic communities. They are well exposed. Now, any questions is there from the audience you can ask, or else we'll come to the last part of the summing up.
Sir, actually there are some questions which have been posted by audience. It is available in the chat box.
Yeah.
So sir, in case if you permit me, may I recite the question, please?
Yes, please.
Yes, sir. The first question that I have received, it is, why the Supreme Court has shown so much urgency in Prashant Bhushan's case, because finally the punishment was just ₹1. And can we say that the punishment was proportionate enough?
Dr. Mino, you want me to answer?
Yes, sir.
I would rather leave it to Rupender Singh Suri, the additional solicitor. Left me, I'm very clear. I made a public statement that this was not the type of cases the Supreme Court should have taken during this pandemic period. And that I still am very clear on that, my statement.
Okay, sir. Thank you, sir. Thank you for your opinion. Okay, Suri sir, would you like to add something in it?
No, I fully agree with Justice Kurian. This was not the time for taking up this kind of an issue. But I have already expressed my views that as far as proportionality goes, it was totally disproportionate. Punishment should have been more if the court felt that the contempt has been committed, and it should have been exemplary. You know, ordinary person, you can be liberal and be compassionate, but a knowledgeable person who knowing what is doing and is accountable for that should have been demonstratively, and a message should have gone to everyone that you cannot take Supreme Court for granted. Howsoever,
Very good.
Thank you, sir. Thank you, sir.
Yeah, I agree in principle with Suri, but I reserve my comments because a review is pending.
That's right.
Right, sir. Okay, sir. So the second question that we have is, sir, Modi sir, would you like to add something?
No. Go on.
Okay, sir. So the next question is, that is, in the recent farm laws will be challenged in the Supreme Court, and could they be set aside on the ground that agriculture is a state subject? The recent farm laws that we have been talking about. So do you think that it can be challenged in the Supreme Court because agriculture is a state subject?
Legal opinion, Kylasanatha Pillay and Rupender Suri, you can give.
I have to defend the government, sir. So Mr. Pillay is
Okay. So, sir, actually, the point
But
is
that's
like,
a question, you know, which is not to be discussed here, because if there are legal grounds available, then that will be challenged. That's all. Yeah.
okay. Thank you, sir. Thank you, sir. Sir, the next question is, and in such cases of contempt, what is the way forward to reduce such cases? Do we need more deterrence or higher levels of professionalism? The contempt, the way forward to reduce such cases. Do we need more deterrence?
To me, I would like to use a third word. We need to show a different level of statesmanship.
Okay, sir. Quick punishment about that. Fine, sir. And the last question that is mentioned here is, after the spy catchers case verdict of 1987, the judges of House of Lords were labelled as fools by the print media of the UK. Sorry, sir. By the print media of UK, but the judges preferred to ignore this comment and no contempt proceedings were initiated. Do you think that Indian judges should be little more tolerant towards criticism? Or I will add that whether the judges of UK should be more disciplinarian over them. What's your opinion, sir?
If it is to me, Minu?
Yes, sir.
Okay. To me, I believe in a philosophy that the king is naked. I must say king is naked. Even if I am naked, and if my king is naked, my nakedness should not stand in the way of my king being exposed as being naked. That's my take on that. And there must be, the people choose not to say that king is naked, then the king becomes more naked. So that should be, that is when if you read section 4, it uses the expression fair criticism. So I agree with Dr. Pillay and Dr. Suri, Professor Senior Advocate Suri. You should be a Professor Suri and Dr. Suri, all of that, yes. That there must be a Lakshman Rekha. I agree with it, because if the Lakshman Rekha is crossed, then there is no limit to which you can. So Lakshman Rekha is for everywhere, but it should be a fair criticism.
If your lordship, I can add, the English judges said that people have said, media has said that we are fools. That is their personal opinion, and we may be fools. They have said we are idiots. We may be idiots. But had they said that the judges are corrupt, we would have taken them to task. Now that part, that had they said the judges are corrupt, we would have taken to the cast of spy catcher case, is not so well published in the Indian context. Because here, judges were told that you are corrupt without giving any evidence of that. Strong action should have been taken. Even British court would have taken an action. Because it undermines the stature of the judiciary.
Agree, sir, 100%. I just agree with your opinions. I think that the strict action must be taken against those people. Sir, I have one last question available with me, And it is, do you agree that generally in contempt matters, the freedom of speech and expression is ignored? Generally in contempt matters, the freedom of speech and expression is ignored. So what's your opinion, sir? Kurian, sir.
It's not ignored. Freedom of speech and expression is not free speech in the sense it is always regulated by those 9 factors I told you under Article 19.2. So it's not unbridled, it's not unguided. As Pillay said, no, there is no power in the Constitution which is unbridled and unguided. Every power is regulated by law. Therefore, even this freedom of speech also has its own Lakshman Rekha, and those Lakshman Rekhas are under the 9 factors referred to under Article 19.2. But mind you, in contempt of court, the first and the best defense is truth.
Yes.
And the person who is charged of contempt of court should be given an opportunity to substantiate the allegation by giving an opportunity to lead evidence on what he believed it was true. And if it is not true, then there must be a punishment.
Right, right, sir. Agreed, sir. Sir, back to Dr. Moni. Yes, sir. Moni, sir. So your opinions and your expert comments on the thing.
Okay. Just I'll be making a summing up, and my duty is to sum up.
Yes.
And we had the talk session started with Honorable Justice Kurian Joseph ji. Was much interpreting on the constitutional, preamble, spirit of the preamble, freedom of speech expression, Article 14, 19, and 21 of the Constitution, dignified life, rule of law, then reasonable restrictions on the fundamental rights. As we were telling, Article 92 and 9 factors that regulates this, and the types of civil and criminal, liability on this this matter, and also there should be the action of the court suo moto or on the petition, how it is taken. And now he has also mentioned there should be a reasonable opportunity for being heard before acting on the person on whom which is this is contempt is charged. And the discussion was very fruitful and has been taken properly. And now I am coming to the views expressed by our Honorable Additional Solicitor General Suri ji. He was basically talking on the rule of law, which is very significant. He was taking the cases of the delegation to China, Russia, and his practical examples. And he was of the opinion that law of contempt is to be there in India, and especially when there are exceeding limits on the media, social media, and other participants of democracy who exceeds the limits. They mean Lakshman Rekha. There should be a proper limit on these things. So he was strongly of the view that it's a proper thing, but should be handled with great care and respect to the judiciary and to the people of India. And he was upholding the values of Constitution to a great extent. And Dr. K.P. Kylasanatha was also talking on the rule of law, then interpretation of the rule of law in India, and he was telling in 2-3 stages of the contempt. And he was telling that the Supreme Court is in the present stage of conciliation. And he was talking on the importance of human rights jurisprudence and how Supreme Courts play a major role by even taking a letter or a complaint as a writ petition, and the importance of public interest litigation and such matters. And that's almost every aspect that is affecting the contempt has been taken forward. We should see that we are having, as a democracy, the judiciary, legislature, and executive. Even I am working in some foreign countries, which like Ethiopia, where the judiciary is under government, because they do not have the independence as there is in India. They are government employees. So even I have taught even Supreme Court judges of Ethiopia, but they were bound by the orders of the Prime Minister of Ethiopia or the Foreign Minister. They have to go because there is no independence of judiciary. So the democracy which we are having and the independence of judiciary which we are exercising in India is very unique. And even the judiciary has, exceeded limits or has not been taken properly in certain countries like Pakistan, where the court will make a verdict and the military will take another rule. Even Chief Justice can be taken into custody, and it happened in Sri Lanka also. Sri Lanka also, the system of judiciary has been challenged in various occasions. So it is not all pleasant that the judiciary has got equal rights everywhere in every place in the country and every democracy specifically. In socialist country, we cannot say, because the socialism means naturally the judges come under the government only. I mean, unitary power exercise is there in the socialism. However, as far as India is concerned, though we have faced various challenges after the enactment of the constitution, we have stood the test of time. And I think our democracy is doing proper. There can be differences, and we deliberate on it, we discuss on it, and we put our points forward, and we put a lot of talks on this matter. However, we are keeping the proper balance of judiciary and executive and administration. So I think India is a great democracy, and if we have to succeed as a nation, we should respect the constitution, which is the largest, one of the largest constitutions in the world, which has been subjected to the maximum amendments. And each amendment has been done with the good sense by the Indian Parliament, and has been upheld by the judiciary. And wherever problem exists, even now, whether it is a political matter or non-political matter or a matter relating to religion, even like Ayodhya issue has been very, very amicably settled by the judiciary. So we respect judiciary, and judiciary should have a kind of control in its hands. And my view is that judiciary is to exercise its contempt power with proper care, and it is also needed. And without this, things can get an imbalance also. So I think India is a great democracy, and I salute the judiciary, executive and parliaments, and all the participants involved in it. Let us hope this democracy goes forever. And I salute Indian spirit, Indian constitution. Thank you. I salute all the members of the all the Indian citizens, because this is enacted not by any executive or not by any people, but by the people of India who have made the constitution in the present form. Thank you.
Thank you, Jai Hind.
Thank you so much. Thank you so much. So again, now it's a time to end up this particular session, which actually I did not want to end. Basically, the discussion is going too well, and I feel like we should be more connected in such kind of events. And it has been an honor to have you all on the dais. Specifically, in case if I have to talk about, it's again an opportunity available to me. First of all, I would like to thank Dr. Justice Kurian Joseph. Initially, I felt like probably it will be a big thing to talk to sir. But the comfort that I had in discussing certain issues and into a very precise time. And thank you so much, sir, for such kind of guidance and deliberations. Then I also thank you on board, Mr. Rupender Singh Suri ji. Sir, it has been an honor to have you on dais over here. Although it's a virtual dais available with us, but definitely whenever the university opens again, we wish to have you again on the campus. Thank you so much, sir, for being here. Then I will also like to thank Dr.K.P. Pillay. A heartfelt thank you, sir. Pillay, sir, can you hear me, please? So, sir, although within few days back, it has been a regular interaction and guidance that I am seeking from Pillay, sir. And on many points and many aspects, we have discussed so frequently. Like, I think I am in a situation to plan this particular event with the guidance of Pillay, sir. Thank you so much, sir, for being there every time. Thank you, sir. Then I would also like to thank you, Dr. Modi. Dr. Modi, although we have heard very few things from your side, but once you have concluded the things, it has been concluded in the most wonderful manner. That while keeping all the things together and just giving your own version of the things. Thank you so much, sir, for attending this particular event. And finally, Dr. Dharam Buddhi, sir, thank you a lot, sir, for just encouraging us and giving this idea, a force behind the event to be conducted over here. Thanks a lot, sir, for your constant support and guidance. And lastly, Dr. Sanjay Modi, sir, you know that always I say thank you to you whenever any event is to be conducted. This is my moral support that I get from you. And whenever you are present in any of the event, you know that we get light from your side, and it is a surety of the things that the event shall go well. Thank you so much, sir, every time for supporting us. Thank you so much. Like now, finally, on behalf of the entire faculty, students, and management of Lovely Professional University, I wish to express my gratitude to all the participants, the panel members, for sparing their valuable time for us and our students. Thanks a lot, and we shall be seeking your guidance in the coming time as well. Thanks a lot. And lastly, the team members that we had, the team members amongst them, which is the team HRDC and team Division of Student Welfare, specifically naming the people, Kuatra sir, thank you sir, and Nitin Bhardwaj sir, who has been a constant support in arranging all the technical issues, whatever are concerned. Thanks a lot, everybody, and we shall be arranging such kind of events in the coming future also. Thanks a lot.
Thank you, Suri sir. Thank you very much.
Thank you, sir.
It was wonderful listening to you. Thank you, Pillay sir. Great interaction. Thank you very much. Look forward to see you sometime again.
And yes, Rupender sir, wonderful meeting you, and we would love to have you again for more of your interactions.
Sure.
Would be my honor. A great privilege.
Thank you, sir. Thank you so much. Thank you, Dr. Modi. Thank you, Dharam Buddhi, sir. And thank you, Dr. Pillay.
Thank you,
sir. Thanks. Thank you very much.
Thank you. Thank you so much. Looking forward, sir. Thank you. Thank you, Dr. Meenu. Wonderfully done.
Sir, thank you all with your guidance. Thank you so much, sir.
Good interaction.